Okay, once again, let me introduce myself. I'm a representative of the Russian Federation at the Federation Council. I am the Russian government's lobbyist at the upper chamber of the Russian Parliament. A very similar position is occupied by my colleague in the Duma. So we have two government's plenipotentiaries with the Russian Parliament. I'm not going to say anything else about myself because we have already exhausted some time due to these technical difficulties. Let me just tell you that we have a very interesting range of different experts represented here. So I would suggest that we run a quick round of introductions, and I guess we will give the floor to every speaker as we go, and we anticipate questions from the floor also. We would like to have an interactive discussion here, we would like to keep it as interactive as possible, so that you're satisfied with the outcomes of this round table. I'm now turning it over to Natalia. Good morning, I'm Natalia Malamina, and I'm a managing partner at Ivanan and Partneri Partners Law Firm. We serve a number of corporate clients. We provide a typical range of legal services, but at some point we realized that in order to ensure adequate protection to our clients, we sometimes need to use some extra influence capacity in order to influence the government. In the civilized world, this is called lobbying. This is why we're so interested in the topic of lobbying and the potential for lobbying in Russia. I guess we should now turn it over to the next speaker to introduce himself or herself. What do you think? Well, Natalia has introduced herself. Perhaps Catherine should also introduce herself, and then we will move on.
I'll start again. Good morning. My name is Catherine Stewart. I'm chairman of Interrel European Affairs, which is a public affairs lobbying agency in Brussels. I've worked in Brussels for about 25 years, and our role is similar to lawyers, but we are not lawyers. We are consultants who have clients right across the spectrum, we will talk about this later, who want to understand what new legislation is being created in the European Commission and European Parliament, and to influence that legislation before it is voted on.
Good morning. My name is Joe Brand. I'm with the law firm Patton Boggs in Washington, D.C. When we began business 50 years ago this week, we were the 37th lobbyist in the city of Washington. There are now 30,000 lobbyists in Washington. We have a very complex government, and our government needs information. Today we have a program for you that will have lobbyists from Russia, the United States, and from the European Union. And I encourage you at any time during the presentations to raise your hand and ask questions. Thank you.
Good morning. My name is Tom Sussman. I'm Director of Governmental Affairs for the American Bar Association, which is a voluntary professional organization of lawyers, almost 400,000 nationwide. And the issues that we lobby on now with a staff of 10 registered lobbyists are mostly directed towards access to justice and legal institutions. My personal history goes back to early years in Washington, 40 years ago when I worked on Capitol Hill for the Senate Judiciary Committee for over a decade. And then I went to private law practice for almost 30 years as a consultant or contract lobbyist and lawyer, working mostly for businesses and associations in Washington. For the past 4 years in my retirement, I've been working for the American Bar Association. And during that time, I've written a book on lobbying law in the United States. which is called the Lobbying Manual, which contains a comprehensive look at all of the laws and regulations applicable to lobbyists.
Good morning, dear colleagues. I am Pavel Tolstych. Right here I represent the Government Relations Research and Consulting Center. This is a company which was founded in 2006. And we have two main functions. One is education and awareness raising. Starting since 2006, we have actively educated and promoted lobbying here in Russia. You may be aware of some of our projects, such as GR Congress and lobbying.ru. GR Congress is an annual congress which brings together some of the most prominent GR experts in Russia. We have also published several books, such as a book on lobbying with the State Duma, a book on GR, as well as a number of surveys and research publications. We also liaise with the media a lot, and we educate a lot. On the other hand, the center is a classical lobbying firm in the American sense of the word. We represent our clients through GR liaisons. Currently, we work for businesses working in 7 fields, in 7 sectors of the economy. In particular, in some of the sectors, we already see the prerequisites being formed to establish GR relations on a professional basis. So we work as lobbyists in those fields. Thank you very much. Thank you very much, dear colleagues. And I guess my first question to you will be related to the whole concept of lobbying, the definition of lobbying. You know that in one of the latest presidential decrees, the government was charged with developing a set of proposals on how to regulate lobbying in Russia. The government is still working on that set of proposals. They haven't been entered into Duma yet. Perhaps this roundtable will contribute to that thinking process. Perhaps there are areas that do not need regulation. So what about the notion of lobbying? This is my first question, please. Yeah, I would like to start with some of the main issues related to the legal regulation of lobbying in Russia. It is no secret that in countries where lobbying is highly developed, such as the US and the European Union, these definitions related to lobbying are part of legal documents and regulatory documents. However, in Russia, by contrast, lobbying does not have a clear-cut legal definition embedded into law. So far, there has not been any serious research into the notion of lobbying in Russia. This is why today, when we say lobbying, lobbyism in Russia, sometimes we have totally different interpretations of this term. In 2008, a group of individuals carried out a research among some of the GR agents of some of the largest Russian companies and professional associations, a survey on GR and lobbying practices. They surveyed over 100 people, but unfortunately, there was such a diversity in opinions that the only thing they had in common was that they agreed that in the mass consciousness, lobbying and corruption are perceived as one and the same thing. And some experts even say that rather than saying lobbying, we should be saying GR in order to avoid the negative connotations associated with lobbying. At the same time, the same experts said that lobbying, of course, is not government relations. Lobbying has a more applied character, so to speak. Some experts unfortunately believe that corruption is one mechanism, one tool, one lobbying tool. But generally they agree that lobbying is a communication practice intended to produce an impact on government authorities in order to have the position of the company recognized and heard. Experts said that the main lobbying tools do not include any monetary incentives. Unfortunately, at the same time, as one of the examples of purely Russian lobbying practices, they cited promotion of corporate practices using administrative leverage and indirect monetary incentives. A lobbyist in Russia is understood as any individual that promotes corporate or business interests on any level and through any means. Sometimes a member of parliament can be called a lobbyist. For instance, if a member of parliament is lobbying for specific decisions, for a specific decision, or sometimes members of parliament will receive some monetary reward from a certain group of individuals in order to push for their interests. Sometimes lobbyists are also understood as professional consultants. Unfortunately, direct monetary incentives, i.e. bribes, are also characterized as part of lobbying activity, and such people are also referred to as lobbyists. For instance, in one media interview, the chairman of the legislation committee of one of the regional legislatures characterized lobbying as his main field of activity. And this is why he introduced into his legislature a draft bill on lobbying on the regional level. And sometimes the media, newspapers will publish rankings of lobbyists. It is a normal cycle when an MP becomes a member of parliament, and then after that, after the end of their term of office, they become lobbyists. Unfortunately, sometimes in Russia, you can find a lot of lobbyists among our members of parliament of various levels. But before we talk about lobbying, we should certainly define the term. There are two meanings of lobbying, narrow and broad. On the one hand, the narrow definition would be corruption, whereas in the broad sense of the word, lobbying is a promotion of corporate interests, and that may also include, for instance, the activities of a senator that defends the interests of his or her region in Senate. At the same time, in the narrow sense of the word, lobbying would be a promotion of a client's interests in exchange for a monetary reward. Of course, there should be a dividing line drawn between abuse of powers, corruption on the one hand, and lobbying on the other hand, because such practices as graft and bribery are criminalized by law. As far as public perceptions are concerned, there is a clear need to institutionalize lobbying so as to take it out of the shady area. Perhaps this is not the most important objective of lobbying institutionalization. I don't think that we should be trying to counteract lobbying in order to try to counteract corruption. I think the main goal of this institutionalization process is to create a procedure that will ensure a level playing field for different public groups to have their voice heard with the authorities. Lobbying also intends to create a feedback loop so that the government can also answer. Unfortunately, currently lobbying is very often associated with violation of antitrust laws, exploitation of opportunistic interests, and so on and so forth. One example of that is amendments initiated by a number of banks in 2010 to the law on pawnbrokers' activities. The charter capital of pawn shops, according to that bill, should be a minimum of 50 million rubles, whereas a typical pawn shop will have a turnover of not more than 3 million rubles. The antitrust service made a conclusion that this bill would violate antitrust legislation, and that it also was in contravention to the interests of small and medium-sized enterprises. Nevertheless, the bill was passed. Another important purpose and function of lobbying is the ability of the government to provide some feedback to various societal groups. Unfortunately, the existing feedback mechanisms are simply not effective enough, and bureaucrats may not have enough knowledge about the different interests and different needs. On the 1st of October 2011, the resolution on changes to customs duties for various categories of goods was issued, and in that resolution synthetic quartz had the same customs charges of some 100,000 rubles as precious stones and precious metals. As a result, sometimes the customs charges would exceed significantly the value of the items imported. These are very important, military critical items, really. As a result of this, one of the largest producers of such items was on the brink of bankruptcy as a result of that amendment. This really jeopardized the health of an entire sector. I think on the 16th of May, not a long time ago, new amendments were introduced in order to address that situation and to reduce the customs fee.
Again, we have to mention that over the last several years, lobbyism in Russia has become more civilized and open. It is not a mass-scale event. Since we represent lawyers community here, we cannot speak of ourselves as of a mass. But at least in Moscow, they started to understand lobbyism as a legal way of promotion of their interests and advocacy of these interests. If the law is passed, we do not know yet whether it will be really working or again a stillborn brainchild of several Duma deputies. There are countries where lobbyism as a phenomenon has been in existence for a very long time, and it is successfully regulated by the legislation in force. However, in Russia there is no such tradition, and if we rely on Russian tradition and Russian soil, we should of course look first into the legislation of those countries where it has been long current. Civilized lobbyism in Russia is still young, and it is not well researched, and there are no easy paths which could lead to the adoption of a sound law about lobbyism. I think the better way to start would be with drawing a clear-cut boundary between lobbyism and corruption, with introduction of the procedure for registration of lobbyists and outlining the major principles for their activities. This is an obvious control measure. But I think taxation of lobbyism is a big question, because, in my opinion, we should first start reforming the whole taxation system in this country, but this is not a matter for our panel discussion. At the same time, the rules which exist today should be reviewed and some of them repealed. In the new version of the Civil Code, it follows the worldwide trends and it finds sometimes a good compromise between the Russian tradition and worldwide trends. However, it took 22 years to prepare that new version. In the same way, the law on lobbyism, it is not going to work perfectly from the very first day. It is not a magic wand. But it should become the first step in building up a tradition of civilized lobbyism in Russia. I think it's high time for that. Thank you, Natalie. You have raised quite a number of issues in your speech. Again, you raise the issue of the borderline between lobbyism and corruption. Where does this boundary lie? And also, what can be the relation between lobbyists and the government? And I would like the speakers to pay attention to that issue. And I would like to invite Catherine to speak about corruption and lobbyism, because it is your subject, isn't it?
I have prepared a short PowerPoint presentation which I thought might be helpful just to outline. Yes, I'm on. Do you hear me? Yeah. It's okay. Do you hear me now? Yes, thank you. I prepared a short PowerPoint presentation which I thought might be helpful. It's in English, but fairly simple English. And I thought we could just quickly go through that, and it covers many of the points that Natalia was talking about from an EU point of view. So there is always this idea that lobbying is something very negative. But actually there are public statements by public organizations like the European Commission, like the OECD, who are saying that lobbying is actually a very valuable activity. And I just give one quotation here from the European Commission, which says that European policymakers do not operate in isolation from society, and they need to speak to society, to all members of society, and we will see who they are, when they are making policy, to ensure that policy and legislation really reflects the needs of the society. And it's very important to have good quality legislation. If we have good quality legislation, there will be less work for the lawyers afterwards, I sometimes think, because much of the problems come from legislation which has not been well created with the interests of all the parties in mind. If I could have the next slide. So there are some myths about lobbying. Natalia was talking about corruption. Actually, lobbying does not need to be corrupt. It can be very fair and it can be very open. It does not need to be linked to money. And certainly at a European level, it is not linked to money. It does not need to be secretive. It can be open. You can say who you are speaking for, and you should do so. It is not only for companies, and it is not only coming from one part of society, and it is not necessarily against the citizens' interests. In fact, at a European level, if I could have the next slide, it is quite different from the US tradition of lobbying. We will hear more about it. It is based on the vision of building a single European market for the citizens and to create a body of law which will be effective throughout the 27 members of the European Union. It is not based on political funding. We do not have systems of paying into the political parties, political action committees, which is very well established in the United States. If I wanted to write a check or give an envelope of cash to a politician, it would be quite hard for me to do it at all legitimately, because there is no mechanism for that. We do not have party fundraising, we do not have political action committees like you have in the United States. And it is quite a technocratic activity. It is not just a question or a word in the ear of a friend who is in the Parliament or the Duma. It is much more about the issue, discussing the problems or the opportunities that that issue gives for your organization. And it can be a company, it can be a charity, it can be an environmental lobby group, it can be many different people. I will show that later. At a European level, it is very multicultural. You have 27 different cultures and countries and nationalities working in Brussels, so it is not based on a single national interest. And we try to make it open and transparent and professional. So as I said, the idea of lobbyists is to create better legislation, to give the legislators more information, a better understanding of the environment in which they are lobbying and of the interests of the people who will be affected, and also to highlight unintended consequences. Have you thought about the impact that this piece of legislation would have in this area or on this section of society? And very often the politicians are not aware that it will affect a company or a group of citizens in a certain way. So that is what we are trying to ensure that they do. So where does it happen? It happens in informal meetings. It happens in formal meetings, which are recorded. You can have consultations when the European Commission will invite 200 or 300 people to come to a meeting to discuss openly a new piece of legislation. It happens in written position papers, which you will submit to the European Parliament or to the European Commission, and in open debate. And in the European Parliament, all the debates are public. They are streamed online. You can go and sit in the back of the meetings and you can hear the debates and you can talk to the politicians in the lobby. And there are various legends about where the lobby came from. The Americans have one legend. The British have another one. In the House of Commons, which is the Duma in the United Kingdom, there is a big open circular space which all the politicians walk through in order to go to their meetings. And this is known as the lobby. And the citizens in the UK could come to the lobby to speak to the politicians who represented them. And so they became known as lobbyists, the people standing, the citizens standing in the lobby, waiting for their politicians to pass to speak to them. That is where the word lobbying comes from. So, who are the lobbyists? As I said, they are not just companies. There are many, many different organizations, and in Brussels now we have thousands and thousands of lobbyists. There is a fictitious figure of 15,000. I would put it closer to 150,000. Because you have people like me, who is a public consultancy, who have clients, and we work on behalf of our clients. Many law firms are lobbyists. But you also have non-governmental organizations, people like the World Wildlife Fund or Friends of the Earth, the environmental organizations. They are lobbyists, and they are very active lobbyists. And it has really only been in recent years that we have forced them to realize and to admit that they are lobbyists also. You have charities, you have think tanks, so the organizations who bring together everybody to have an intellectual debate about issues. You have the big corporations, but you also have the churches. I have heard politicians say that the churches are some of the hardest lobbyists when they are talking about issues, particularly bioethics, stem cell research, in the whole medical field. The churches are very, very powerful. And you have all the local, municipal and regional authorities who have their presence in Brussels, and they are also lobbying for their own interests. So who is lobbying who? As you see, it is an enormous spider's web of connections, because not only are these organizations that I have mentioned lobbying the European institutions, but these institutions are lobbying themselves, each other. So you have members of the European Parliament lobbying the European Commission to change the draft of their legislation. You have all the national governments lobbying the European Commission to make sure that the French point of view is understood better than the German point of view or the Italian point of view. So we have this whole process, which is long and very, very complicated to make legislation. But it does ensure that the maximum number of people and their views and opinions are heard in the process. One of the classic concerns about lobbying is the influence of money. And people say, you know, money brings influence. And that, particularly at a European level, is not true. Because, as I mentioned, there is no system of political donation, which in some ways brings obligation on the politicians. We don't have fundraising for political parties at a European level. Bribery is illegal, and if anyone is caught bribing, they go to court. And the influence in Brussels is much more on good argument. And so this is really fundamental in the whole concept of lobbying at a European level. As I say, why lobby? To make people aware of problems, to influence, that is what we are doing, but no one representational organization is the only influence. The better your arguments, the bigger the constituency that you represent, the more likely you are to bear influence. But I have seen many cases of very small special interest groups having an enormous influence. I have one example, which is a very big piece of legislation about chemicals and chemical testing, which was inspired by the environmental organizations, which were worried about the amount of chemicals which are persistent in our blood system. And they organized a blood test. And one of the senior commissioners in Brussels, who was responsible for environmental legislation, agreed to have a blood test. And they published the results to say that they had found persistent chemicals in her blood test. And they did a fantastic press campaign about this. And as a result of that one very clever promotional campaign, one of the most enormous pieces of legislation that now affects every multinational corporation, which is known as the REACH directive, which is about registering chemicals, has come into place. And that is despite the lobbying of the biggest chemical companies, petrochemical companies, food companies throughout the world. They were very concerned about the cost of this legislation. But one small campaign by an NGO could bring in this enormous piece of legislation. And they claim they have no money. So you see that you can have a lot of influence with very little money. But transparency is very important. About lobbying, what is important about lobbying is for people to know who you represent and why you are representing it. And so we have set up an organization, which is the Society for European Affairs Professionals, SEAP, and we have built this concept of an ethical code of conduct, of transparency and ethics when you are lobbying. So we represent individual European affairs professionals, and they can be in any sector that we have talked about. We set standards, and we act as a coordinator between the European institutions and professional lobbyists to support transparency and professionalism, to train people in how to do this correctly, and so that we maintain credibility for the profession, so that it is not something which is a nasty, dirty activity, but it is a respectable activity to be a lobbyist. And as a result of this work, we have worked very closely with the European Commission and the European Parliament, and they have set up a voluntary register. It's called the Transparency Register, where you can register your interest, you declare whatever financial interests there are, and you agree to apply by a code of conduct. And when I looked last week, there were 5,000 organizations registered, and I should have given the line, but you can Google it, and you go on the Transparency Register. And it's fascinating. Maybe later I have an opportunity to. The range of people that are registered is quite enormous, and puts a lie to the fact it is only corporations who are registering. So, a few do's and don'ts: no money, don't lie, be careful about Facebook, respect confidentiality. And that is the code of conduct which we all have to sign, that we should identify who we are, say who we represent, ensure that all the information we give is clear and transparent and complete and accurate. We should not try to get information dishonestly. We shouldn't bribe officials. And if we employ people who used to be officials, we have to respect all their obligations for confidentiality from their previous jobs. So that is just an outline of how lobbying is now seen in Brussels, is being practiced. It is still regarded rather negatively, but in fact, so many people do it. It is a way of life. But what is important is that it is done according to these good codes of practice to ensure that everybody's interests are best represented, and it will create a better quality legislation at the end. Thank you. Thank you.
Спасибо, Кэтрин.
Thank you, Catherine. Very important issues have been raised in this presentation. I would like to tell you that I found out a very interesting subject matter regarding registration in European Parliament. The similar subject matter could be devised in the Parliament of the Russian Federation. The Parliament of Duma and the Council Federation allows to settle and regulate these norms. It concerns not just federal legislator, but there are legislators of the entities, and Pavel, I think, will later talk about that, because there are certain duties of the entities, for example, tax breaks. So it's a multi-level, multifaceted aspect that could be considered in the parliament. I also enjoyed your statement regarding a reference to American traditions. We have two representatives of American school, Joseph or Brent, who could tell you more about the experience of American lobbying tradition.
Thank you, Andre, and thank you, Catherine, for your presentation. Let me tell you why we need lobbyists in our system of government. In every day, the Congress publishes its proceedings in a document called the Congressional Register. And every day, all the rules and regulations promulgated by the various ministries of our government are published in a document called the Federal Register. Now, the day before I came here, I counted the pages in the Congressional Record. There were 233 pages. The Federal Register that day had 551 pages. So that's 784 pages of laws and regulations and debates. We have 535 members of Congress. They are supported by a staff of many thousands. it would be impossible for any one legislator or any one staffer to read every day, every page of the Congressional Record and the Federal Register. Lobbyists, on the other hand, sort through these things for their own specific interests, and as Catherine said, they're not all corporate lobbyists, and my colleague to my left, Tom Sussman, proves that point. He is a lobbyist for the American Bar Association, the voluntary association of lawyers in the United States. In my own practice, in my law firm, we represent many universities who lobby the Congress for their own special needs. So the first reason we need lobbyists in the United States is to provide information to our government. Now, our lobbyists are registered by two different laws. One is called the Lobby Disclosure Act. Tom has written a book on that, and I'm going to ask him to speak to that. The other is called the Foreign Agents Registration Act. If, for example, I'm lobbying for a foreign government, I have to register under the Foreign Agents Registration Act. If I'm lobbying for a particular NGO or university or corporation, I have to register under the Lobby Disclosure Act. These two have different rules, but the general theory of both is disclosure and limits. Disclose who the client is, and on the limits, there are certain obligations we have not to provide money to members of Congress or to their staffs. And with that, I'd like to ask Tom Sussman to describe how he understands the regulation of lobbyists to be in the United States.
Thank you, Joe. I'm going to start by taking the liberty of trying to synthesize a number of things that were said so far as principles governing lobbying and lobbyists, and then move into the regulatory domain. I think you've heard from a number of speakers the rapid growth everywhere in the European Union, in the United States, in Russia, and it certainly is. I've had experience in Latin America and elsewhere around the globe of lobbyists and others who perform the function of lobbyists in representing employers or clients attempting to influence government decision-making. And the reason, I think, is, as Joe Brand made so clear, is the growth and complexity of government itself. And, of course, the influence that government has on the lives of all of us. And, as Joe also said, lobbyists are indispensable to informing government decision-making because there's no way, for example, that legislators or parliamentarians can possibly understand the impact and implications of what they're considering without the information, the data, the surveys, the expertise that lobbyists bring to the table. You've also heard a good deal about the association of lobbying and corruption and the negative perspective that the public has on lobbying. Part of that comes from the fact that lobbyists are influential and, of course, have the ability, because of that influence, to corrupt government decision. Part of it is historical. Lobbyists have, in fact, in the United States, in Russia, in Europe, all around the world, lobbyists have been associated with corrupting activities, most of which occurred in the past before the era of disclosure, transparency, accountability, and lobbying regulation. And of course, the media have a tendency to magnify the negative aspects of lobbying while ignoring the important positive benefits that lobbyists bring to the system. Having said that, I think it's probably goes without saying that democratic governments require a level of legitimacy to function effectively. That legitimacy derives from the trust and support of citizens, and that the regulation of lobbyists can be effective in countering the public perception that we are engaged in undue or inappropriate influence. And the stronger the transparency, the stronger the regulatory framework, the greater the likelihood is for public acceptance. So having said that, it should be clear by now already I am a proponent of strong lobbyist disclosure regulatory regimes. The United States developed its first lobbying disclosure law in 1946, but it was a very vague and weak law. We replaced it in 1995 with a stronger, clearer set of definitions so that lobbyists who are paid, who are compensated at a certain level to have communications with decision makers in government must register, and in that registration they must disclose their client or employer and the issues that they expect to be working on. And every 3 months, quarterly, each lobbyist must file a report, not just repeating who they are working for, but what issues specifically have been addressed, whether they've been at an agency or the House or the Senate, and how much money they have received, or in the case of an institution, employer or association, how much has been spent during that quarter in lobbying activities. That law was most recently updated and expanded in 2007 when the regulatory aspect was added to it that Joe mentioned, prohibiting lobbyists from making gifts or offering travel to government officials. So now, in my view, in the United States, any suggestion that lobbying should be identified with corruption is simply misplaced, because we have the most pervasive disclosure regimen and resulting in the most transparent lobbying, and I believe the most honest lobbying that exists in any national system. And the reason is because the legislation that I've briefly described establishes limits. It reassures the public that we do abide by laws and will disclose what we're doing. It informs government officials who lobbyists are working for and how much they're bringing to the table in their lobbying programs. It levels the playing fields to some extent because lobbyists know what other lobbyists are doing. And ultimately, that level of transparency fights corruption. So the essential elements, in my view, although I understand and respect the voluntary system of lobbying disclosure that exists today in Europe, I guess Germany, a number of countries that have voluntary systems. But for the most part, those systems don't provide the assurance to the public that they know all there is to know about the forces that are influencing government decisions. They don't tell lobbyists who's on the other side of issues. And they don't tell government officials where the sources of influence might be coming from. So I'm a supporter and proponent of a mandatory governmental enforced public disclosure system for lobbyists. And a few years ago, a colleague and I did a survey of lobbyists to determine what attitudes of lobbyists were towards regulation, and discovered large majority of lobbyists support some form of regulation, either self-regulation or government regulation. The closer lobbying is perceived to be related to corrupting influence, the stronger lobbyists believe that there should be government regulation. And that is, in some ways, out of self-defense, that we can provide legitimacy for our own professional activities only when we can be certain that there is a comprehensive scheme for public regulation and transparency. One last word, because in the United States, we have many laws that go beyond just lobbying disclosure, including not just the Lobbying Disclosure Act and the Foreign Agents Registration Act, but of course a whole array of criminal laws against bribery and corruption and fraud that often implicate, unfortunately, the work of lobbyists. We have codes of conduct for public officials, and our voluntary lobbyist organization, the American League of Lobbyists, has adopted also a code of conduct that is binding on members of that association. We have strong rules relating to campaign financing, but that is probably the one area in the United States where our laws are not adequate to the task, because lobbyists are heavily engaged in raising money for members of Congress and officials running for election, and there's very little control on the role of lobbyists in assisting in campaigns, and it is that level of reciprocity generated by the lobbyist responsible for a member's election that can come back and provide an undocumented level of influence once the member is in office. And finally, what we do not have in the United States, but what exists in Canada, and I've been a strong proponent of creating in the U.S. a commission or authority that has the power to provide advice, to give interpretations, and ultimately to investigate violations of the Lobbying Disclosure Act. Canada has a lobbying commissioner that has broad authority to supervise and oversee lobbyists, including enforcement of a code of ethics in Canada. And in my view, that is the one area that, along with stronger campaign finance regulation, would help complete the circle of a fully comprehensive U.S. set of lobbying laws. Thank you.
Tom.
Thomas, thank you very much for this comprehensive overview of the U.S. tradition of lobbying. I think I have picked up a number of very interesting points here. What it teaches me is that there are no cookie-cutter solutions, really, when we ask ourselves the question whether we should opt for very stringent regulation in Russia or we should be in favor of voluntary regulation. Perhaps Pavel could also shed some light on the different approaches that exist in his presentation, and I could also throw in a few comments here. I think we have already addressed some of the questions that the government is now facing in response to the presidential decree. I would also like to talk about some of the sectors, and I guess Pavel is going to focus on that because your company works with 7 sectors of the economy. Last year, I saw 2 campaigns for 2 draft bills which were passed, and that had to do with lobbying capacity of different groups. You remember there was a law on assets under which a number of assets were transferred to churches and church-based organizations. There was a whole program of action which was developed first. The task force worked on that bill, and they were able to lobby for the bill very actively. The alcohol sector, the spirits, also lobbied quite actively last year, as a result of which beer was categorized as essentially a liquor, which led to increased customs duties, taxes and so on, excise duties and so on and so forth. This is another interesting example. Perhaps, Pavel, you could also address these 2 examples in your presentation. Dear colleagues, I prepared a PowerPoint presentation. Could you please show it? The organizers asked me to make an overview of lobbying in Russia today, professional lobbying in particular, so I would like to share my perspectives on this, and naturally I will be comparing lobbying with other jurisdictions that and other practices that are observed around the world. Let us open the first slide now. Well, this is the definition of lobbying so that we can put ourselves on the same page. This is a group, a very professional audience here, so I don't think I should be really preaching to you and explaining to you very simple things. I understand lobbying as a political institution which is represented as a process aimed at promoting interests of individuals, corporate structures, as well as organizations representing their interests with various government authorities with the purpose of achieving a beneficial political decision in their favor. Two aspects of this definition. Lobbying has to do with private interests. This is part of the nature of lobbying. This is a sort of a feedback channel between society and the different government authorities. It's a link between the private and government sectors. This is something that was emphasized today already, but there's another aspect which I think merits attention here. When we discuss lobbying, we should understand that we are talking about legal activities only. It's an axiom, really. If we are confronted with practices that have to do with influencing political decisions through corruption, bribery, or any other such practices, they are not lobbies. They're not lobbying. What they are is corruption, trying to pretend to be lobbying. If you provide bribes, you're not a lobbyist, really. And this is very similar to lawyers and lawyering. Lawyers represent individual interests with the authorities, with the judicial authorities, whereas lobbyists represent private interests with the law-making bodies as well as executive authorities. Just as a lawyer tries to influence a court decision, advocating for a certain position, the lobbyist will also represent the interests of different influence groups with the lawmakers and the executive authorities. These are some of the very important aspects of this definition that I wanted to highlight. Further on in my presentation, I'm going to talk about what we call economic lobbying and the different economic lobbying agents. These include primarily corporations, namely their government relations departments. The corporation is trying to influence the government through its GR function, through its GR representatives. Business associations is another category of agents. These are not-for-profit organizations, professional associations, business organizations that advocate for their interests with the organs of power. And finally, there's another category, professional consultants that serve the interests of professional associations as well as corporations in order to maximize their lobbying impact. Let me now talk in more detail about each of the categories. First of all, let's talk about corporate lobbying and what it looks like in Russia today. Just as I said already, corporate lobbying is usually done through GR departments of companies, the so-called GR departments, but they may be called differently, of course, in different companies. External relations, communications, public affairs departments, they're sometimes called. Doesn't matter what they're called, but their main purpose usually is to have a structured process of communicating with the authorities in order to represent the interests of this company, of that sector. In the last 10 years, Russia has seen a boom in terms of companies starting these departments within their structure, both Russian and foreign companies, privately held and government-led held companies predominantly have such GR departments within their organizational structure. If we take Russia's top 300, 400 companies, no matter what their form of ownership is, they all will have a GR department of some sort. This is a new trend which started at the turn of the century, back in the 1990s. Some companies had such departments, but this was not a typical practice. GR departments seem to be proliferating really. All major companies already have them. Some of the largest GR departments are found at Russian Railways Corporation. They have about 30 people in their department. Rusal used to have a rather big GR department, about 15 people. Tobacco, Philip Morris Tobacco, and other tobacco companies usually have pretty large GR departments. According to our estimates, there are about 1,000 GR employees in the Russian corporate sector who permanently, on a permanent basis, represent the interests of their respective companies with the lawmakers. So this trend is evolving fast in Russia. Forbes magazine in 2011 called the position of a GR expert as one of the most promising and potentially lucrative professions or positions in the Russian corporate sector. We really appreciate, we people who work in GR, we really appreciate that despite the fact that Russia has a very big bureaucratic system, we now have more and more people who are professionally skilled to develop relationships with the bureaucracy, and this trend is not going to end anywhere anytime soon. The compensation of GR people is also growing in the Russian corporate sector. Currently, people of the rank of Vice Secretary for Government Relations earn over $1 million in the Russian corporate sector. A number of interesting examples can be cited here. This profession, unlike other corporate professions, seems to be really growing in prestige, and the compensation levels are growing as well. We as consultants also find it a welcoming trend that companies spend more and more of their budgets on GR. This may be related to corruption also. However, the overall trend seems to be that GR departments now have budgets ranging from 0 rubles. For instance, the Magnitogorsk Combine has the following policy: if you are a GR expert, you don't need compensation. We hire you so that you can earn money. So between 0 and on the other end, it can be several $1 million, especially in corporations like Alpha Group, as well as some US companies present in Russia, companies that traditionally focus on these activities. We have panned the corporate scene. Now let us look at the different sectors and where lobbying occurs. Lobbying of sectoral interests usually happens through various business associations and professional organizations such as the Russian Union of Industrialists and Entrepreneurs, the Business Russia Association, and so on and so forth. So if you work in a specific sector, you can have your voice heard through a professional association, organization, or sometimes a chapter or a committee with some of the largest Russian business associations, as well as chambers of commerce such as AmCham, the American Chamber of Commerce, and so on and so forth. As to the level of professionalism among lobbyists in Russia, there are only a very few organizations, professional organizations that have the necessary skills, that are professional enough, that know how government works, that work very actively with the lawmakers as well as executive public officers, and organizations that are able to achieve their goals effectively. This mainly happens in the insurance sector and the banking sector. For instance, if you look at the insurance companies and try to track some of the achievements over the past several years, the record is really impressive. They have been able to use political leverage in order to increase the capitalization of the sector as a whole dramatically. Again, there's a lot of diversity and heterogeneity in this sector. I would say that corporate lobbying usually prevails over sectoral lobbying. In other words, companies prefer to act through their own GR departments rather than joining efforts with others in the industry. For instance, some of our energy companies have work in this way. Tobacco companies have powerful GR departments within their structures, but if we look at the Tobacco Producers Association, they're not really very active. Then we also observe that some associations are underfunded, have a shortage of professional skills. Some associations are effectively pocket associations created by a single corporation, a corporation that wants to have a more comfortable position when talking to the government. And then there are also organizations, professional associations that mainly consist of retired professionals, people who do not really represent the sector as it stands today, people who are incapable of effectively lobbying for the industry. The outcome, the main outcome, the outcome, this situation actually leads to a number of challenges and difficulties. In general, I would like to say that a professional association today in Russia is not really involved that much in active or proactive lobbying. What they usually do is they sign petitions to the government. Usually these petitions are developed by GR departments of certain corporations, and the association will simply sign it. Another function of these associations in terms of lobbying is to provide comments to the media, so their input into the process is not really very significant. Let us move on, dear colleagues, and talk about another category or another level, professional lobbying consultants. I believe that this is going to be of particular interest to our US colleagues. We have representatives of some of the largest lobbying companies in the US here today. Well, professional consultants are usually businesses that provide fee-based services to their clients on how to work with the government. The key clients, the key customers that they have are corporations and other business organizations. So who are those professional consultants? They are, first of all, professional mediators or professional companies. Even though there is no law on lobbying, they position themselves as lobbying firms. These are legal entities. Overall, Russia, even though it's a very big country, only has about 15 such firms. There are two categories within this. Within their composition, there are purely Russian companies on the one hand, and on the other hand, divisions of foreign companies, for instance, Cassidy Associated. Then we have PPN present here also. And by the way, Patton, what's the name of that company? Yes. Yeah, this is a remarkable company indeed, because if they're mainly a lobbying company in the US, in Russia they mainly function as a law firm.
In fact, the market for lobbyists is fairly diverse and not very big, really. Quite a number of companies have already wrapped up their activities over the last several years. And foreign companies much less prominent in this market than the Russian companies, who can also be professional mediators in the aspect that we are discussing now. They are major law firms. If you look at, there are about 10 of those in Russia, you know them. They are major Russian companies, to a lesser degree foreign companies like Yapam, Vegas Lex, well-known companies that, alongside with their legal practice, they also offer lobbyist services. And the last group is the PR companies. Before 2004, when we still had elections, they were in political consultancy. But when the election system was changed, both to the State Duma and the Federation Council, some of these PR companies, without much success, have switched to lobbying. And now they offer these services in their package. If you assess these professional consultants, well, usually there are no more than 10 consultants in a company on the payroll. They invite people from outside when they need a better effort, and their turnover is about $10 million per year, not more. Mind that I speak only about legal lobbying without any, not involving any bribes or other misdemeanors. Well, what they do, they help in developing the legal acts. They take part in shaping the customs and tariff policy. They are in political networking. They support companies in foreign markets. As distinct from the US, we do not have any budget lobbying, just because our government officials, they are okay with splitting the budget. They do not need any support in that. And finally, I can offer a comparative analysis of what is going on in Russia and in the world. US, the turnover of lobbying is on an average $3 billion per year. Of course, it varies from year to year, but the professional lobbying generates about $3 billion. In the US, we have about 15,000 about 15,000 professional lobbyists. After the 95 law was passed in the times of Bill Clinton, that figure is stable. In Canada, 5,000, in the European Union, about 15,000 of registered lobbyists. In Russia, the budget of the sector, and I include budgets of lobbyist companies, consultancies, associations. The total amount, sum total of their budgets is about 500 million. In Russia, it is an estimate only. You can but guess. About 2,000 people are in this business, in legal companies, in consultancies, and so on. There is no professional association of lobbyists in Russia. We are on the verge of putting it together. The latest initiatives by President Medvedev were conducive to that, but there is an association of PR experts, and so from time to time lobbyists also get together under the aegis of that organization. There is practically no professional education for lobbyists. There are separate courses which are taught at some universities in Moscow and St. Petersburg, but there is a definite lack of teachers and coaches. If I can have some 5 minutes more, I will also say a few words about the law. The federal laws were adopted in the US, Canada, Australia, the EU, in Taiwan, Poland, Lithuania, and Hungary. In Russia, there is an opinion that this law will make bribing legal, but its essence is generally it will grant the lobbyist certain rights in exchange for a higher liability. The lobbyists will have access to various branches of power, legislative and executive powers. They will have also the right to get information and process it, and a number of other rights and liberties. But granting these rights, the authorities will also impose certain liabilities. They will have to be open, accountable, and they will have to report to the authorities on how they spend their budgets. Also, an anti-corruption strategy was adopted in Russia for 2012 to 2014. This strategy, of course, it was made public in the pre-election period, as usual. But speaking about lobbyism and the differences between, say, Russia and the US, there are two major differences. First, we have to understand that lobbyism and its efficiency they depend upon the degree of development of the political system in the country. And here we have a great difference, because American Congress is totally different from the Russian Duma. First, Congress is very influential, and it shapes both the legislation and the budget expenses, distribution of budget. A Russian Duma is much weaker. Practically it doesn't influence anything, and this is very important. Second, the electoral system in the country is very important for lobbyists, because you know that American Congress is elected according to the majority system, while Russian Duma is elected on the proportional system. That means that the Russian members of parliament, they practically are not accountable to their constituents. And all lobbyism is not open. It is somewhere on the sidelines behind the curtains. So it is next to impossible for Russians to operate like Americans do, beginning with grassroots lobbying in the parliament. Russian MPs, they don't have to think at all about their electorate. Russian public politician, it is usually practically is a government official, a bureaucrat. His faction in the Duma, his party, is much more important for him than his constituents. And as long as we have no civil society, as long as there is no direct dependence of politicians on their constituents, we won't be able to institutionalize lobbyism as it is done in the US and in EU. It will always be a shadow occupation. Now, the executive power in present-day Russia is super influential in the political process. Thank you. Thank you, Pavel. You've raised another quite a number of disputable issues. Perhaps there are questions to our speakers from the audience. Please introduce yourself. Радио, микрофон дайте. Svetlana Vasilyeva, assistant professor from the Higher School of Economics. I would like to ask our American colleagues. Yesterday, a representative of the University of Columbia, Tim Wu, said that the procedures of lobbyism and the open government are being improved now in the US. The open government, it presupposes that citizens will have more instruments with which they could influence the policy in the country. And he also said that there is an opinion that it is the open government that should be developed and not lobbying, because it should replace lobbying after all. Since you represent companies that are professional lobbyists, do you really support his opinion? And can we expect that there will be changes in the US legislation on lobbyism after 2027?
Understand the difference between open government and lobbying. I think I'd have to have more information about that. I don't believe that there's any change in the offing for our lobbying laws. As I think both Tom and I have said, our government is an extremely complex government, and information is vital to the Congress. The Congress could not possibly operate without the information provided by the lobbyists. With that, I'll ask Tom for his comment.
lobbying disclosure is one element of open government. We have many other elements, financial disclosure requirements, product-related disclosure, securities disclosure. The U.S. system has many aspects of specific requirements for transparency, including an overarching freedom of information law and open meetings laws. All of these, I think, encourage more informed public participation in government decision-making. And as I think Catherine mentioned in the European context, we're talking about corporate lobbying and association lobbying, but everyone has lobbyists in the United States. Very strong animal rights lobby, very strong lobby for victims of cancer, not just hospitals, not just doctors, not just pharmaceutical companies, but the victims. So that it's these many voices combining in a very open way to ultimately have their influence. And I think more organizations are turning to lobbying because it's very difficult to be heard in Washington these days. There are so many voices of so many interests that having a professional lobbyist, even if you are a government, a church, a small nonprofit charity, it's very important to be able to get that message across.
Спасибо. Коллеги, есть еще вопросы? Пожалуйста.
Thank you. More questions? Dear colleagues, my name is Zakharov Roman. I am from a law firm. My question can be split into two parts. One part for my Russian colleagues and the other part for our colleagues from the US and the EU. In our system, legal lobbyism will be in competition with what we have now as lobbyism, all those informal cronyism and relations. Why do you think this legal lobbyism will be more attractive to people instead of what they have now? And asking our foreign colleagues, why do you think legal lobbyism has won an upper hand over the under-the-table lobbyism?
I think that we first give the floor to the Russian colleagues. Actually, you started your presentation with it. So it depends on what do we understand by traditional lobbyism in Russia and legal lobbyism. If we consider traditional lobbyism and the notion of lobbyism as some arguable methods, I wouldn't like to use the word corruption. So the advantages of legal lobbyism imply transparency, openness, and lack of criminal punishment. It's like going on the razor's edge. On the one hand, there is a criminal code and responsibility for legal activities. On the other hand, you can declare transparency and openness and work as a professional consultant on a legal basis. And so all the advantages are seen here. It refers to the matter of corruption, which also involves mentality, but not specific types of activities. Unfortunately, corruption element sometimes seems more alluring, lucrative. Thank you, Natalia. I would like to add, moreover, after ratification of 2 international conventions, anti-corruption conventions, yesterday the plenary session, colleagues from the USA mentioned that they were talking about prosecuting foreign companies in American jurisdiction, and I would like Catherine to say something with regard to this matter as well.
making lobbying a more open and acceptable practice is that it puts obligations also onto the legislators and the policymakers. When they were discussing the transparency register in the European Parliament, the Parliament introduced a very important concept, which was an obligation on all the parliamentarians to declare whom they had spoken to when they were discussing a piece of legislation. And it was known as a legislatory footprint. So the Member of Parliament had to declare everyone that they had spoken to. And this is therefore forcing the legislators to be transparent too, because if they have had quiet conversations in the shadows with other people, that is going to be seen as being equally corrupt from their point of view. It takes two to corrupt, in fact. It is the corrupter and the person being corrupted. So you are forcing the legislators also to be transparent and open, and you are forcing them to consult more widely with a much wider range. And I would just like to confirm what Thomas was saying. I pulled out of the Transparency Register the statistics of there are only 5,000 organizations registered. There could be many, many more. But in fact, the companies, the in-house lobbyist companies, there are 657. But the non-governmental organizations, some of the people that were being mentioned earlier, 1,400. So twice as many non-corporate interests registered than there are corporate interests. And I think that's very important to be aware of. Lobbying is not just about the corporate private sector in Europe. It is the whole range of civil society. And the more that they also are forced to come out into the open because they represent very narrow interests often, the better quality legislation we will have and the more assurance we will have that our legislators are really consulting widely and representing more widely the interests of their constituents. And particularly so when Pavel was talking about the role of your members of your Duma, where they have very little representative obligation from the people, it is important that the people and the citizens are given that access to inform them and to influence them. Thank you.
To the question about under-the-table lobbying, I have two words to answer that. Jack Abramoff. Now, why do I say Jack Abramoff? Jack Abramoff was a lobbyist in Washington, D.C. He engaged in illegal lobbying activity. For example, he took a group of congressmen to Scotland to play golf. That is not lawful under our lobbying rules. What happened to Jack Abramoff? He went to prison. He was in prison for, 2 years? He just got out recently. So we have criminal laws that would apply to people who engage in illegal lobbying activity, and they are very rigorously enforced.
Let me add something. That's, with respect, that's a very strange question for a lawyer to ask. Why should legal lobbyism replace traditional under the table? I mean, it's sort of like asking, why do we have rules governing traffic? Okay? Because after all, if we didn't, some people would get there much faster without any rules, right? It's much more efficient to have rules. It builds much higher level of public confidence in government and in lobbying, and fewer people get injured along the way. So, I mean, as a lawyer, having a framework of laws governing an activity as important as lobbying is significant, because after all, lobbyists do affect public policy. I mean, many of us are lawyers. Private lawsuits, someone wins, someone loses, money changes hands. Everybody else is not affected for the most part. A lobbyist goes up to the Duma, to the Parliament, to Capitol Hill, gets a decision made for that lobbyist employer or client, and everybody in the country is affected in one way or the other. So it's an area that cries out for rule of law.
Спасибо. Прежде чем коллеги...
Thank you very much, Tom. Before I ask a question, so I really like the viewpoint of Catherine regarding the point that lobbyism represents not just private interests, but general interests of any sectoral groups, any organizations. I can confirm that such institutions as commissions for draft law has been created until recently, just a year ago. None of the associations have been represented there. Pavel was talking about. Now the voice of these associations at these commissions is the loudest. And you know, they're proactive and they say this is the norm or this standard, whether it will be applicable or not, and we'll listen to them. A commission for administrative reform has been created where the draft laws of any bodies of executive body, antitrust service or customs service are considered, and the association which represents the interests of this or that sectors so are considered from the viewpoint of assessment of the regulation effects. And once again about information. There is a lot of information on the websites of the federal bodies of ministries. The question is, who can work with this information? Who can dispose, and how can they dispose of information? How shall we use that information? I think that the lobbyists, as we call it, could professionally and competently convey to the interested groups this viewpoint. And once again, colleagues, I would like to make a comment regarding political system. Pavel said that, you know that from the 1st of June, there is a new order of elections for the governor's position. The 1st of June 2012, so the new order has been made, and so there will be elections based on that. And the Council of Federation, where I represent the government, has elaborated and represented to the President its own draft law about elections of the members of the Council of Federation, and they have to combine these elections of governments, and there will be elections, and the senators will be also elected in the Council of Federation, and an approach to elections on party lists also is being changed. So the system is not stagnant, it's being changed, and there are opportunities to regulate the Institute of Lobbyism as well. Alexei Kromov. I have very great interest to this session and topics. On the one hand, I'm the head of the Penaplex law company, and I'm also in research regarding historical aspects of lobbying. And in this today's presentation, I've been interested by the phrase by Mr. Brandon, where he introduced the statement that lobbyists in the US are the suppliers of information for the Congress. In this connection, I have a question. Is lobbyist activities, is it paid? If it is paid, how does the Congress of the USA receive information from the population who are not capable to pay money for lobbyists for their activities?
I'd almost have to have a specific example to be able to answer that question with any authority. In general, all special interests are represented in the Congress one way or the other, most of them through lobbyists. If, for example, Chevron, a major oil company, is lobbying one issue, then you can bet your last dollar that that issue is being very aggressively lobbied on the other side by the environmental lobby. So there are checks and balances because, as you've heard from both Tom and from Catherine, the majority of lobbyists work not for corporations, but they work for civil society.
I think Joe's point is really an important one when compared with what we've heard about Russia, and that is the high level of sophistication of lobbying by civil society, and the fact that what we call grassroots or local movements by consumers often are able to overcome the lobbying activities of banks, for example. We recently had an example of banks trying to get charges imposed on certain use of transactions. And the public simply, the consumers from around the country simply revolted. And the banking lobby historically has been considered one of the strongest lobbies in our country. And yet they've lost some of these battles, very important battles, to consumer advocacy in the United States. And I think that will continue. The other thing is, even for professional lobbyists, and I'm sure that this is Joe's experience, we rely very heavily on constituents. That is, people from home districts and states who actually vote for members of Congress. I mentioned campaign finance, and certainly that's one route to get the attention of a member, but the most significant and reliable route is through constituents. And often the lobbyists can organize the constituency to be heard, but often it comes from the constituency at the local level without even a lobbyist's involvement.
Уважаемые коллеги,
Dear colleagues, let us agree upon.
закончить ответ.
May I just add one small point? Technology is transforming lobbying, because you talked about information. Technology now enables everybody to provide information at no cost. You can blog, you can Twitter, you can have Facebook forums, all the rest of it. So we are seeing lobbying actually as having to find an alternative way of being heard from just providing information. And in fact, this is why lawyers are good lobbyists, because it's about advocacy. It is how do you frame an argument to be most convincing. And so lawyers who are trained in the skills of advocacy are very good at that, as are people trained in the skills of communication and PR. You can have all the information you like, and the lawmakers are overwhelmed by information. But how do you really make your case that your point of view is the most valuable and important? And that is the real skill in lobbying.
Уважаемые коллеги, спасибо, Кэтрин.
Dear colleagues, thank you, Catherine. So I have to say that we are working 1 hour and 50 minutes. There are a couple of more questions. Let us give a chance for people to ask questions, and after that we will wrap up. Mike, please. Good afternoon. Alexei Makarov, a deputy of the Legislative Assembly of St. Petersburg. I have a question to the Russian participants, maybe some kind of provocative. Don't you think that legal lobbyism as a professional paid service representing the interests in the power borders somehow contradicts Russian mentality? I mean, the commercial activities. Just imagine what will be the relations in our society and the attitude to the commercial lobbyists, to the lobbyists in the Orthodox Church. I think negative attitude. What's your viewpoint? Pavel might start. You know, good question. You know, commercial lobbyists in the Russian Orthodox Church do exist. They don't name themselves. They don't call themselves as such. The issue is to attribute some legal framework. Another issue, another question is, as to lobbyists, as advocates, no one treats them very positively in the world. There are several reasons. One of them is lobbyists stand for private interests in power bodies. They don't think about public interests. You, as deputies and your officials, have to think. Lobbyists here represent interests of corporations. When you stand for some narrow interests and you don't think about public benefits, so people will be alert to you. Another reason is lobbyists from time to time, so are caught and corruption and graft. The US always mention some examples. Europe has some cases. In Germany, just imagine scandals related to Mercedes, Hyundai in the Far East. So it takes place from time to time. You cannot judge that. Nevertheless, this so there is some imprint. And another reason, maybe indirect, lobbyists have always been earning good money, and there has been historically quite a negative attitude. Thank you very much, Pavel. Anton Dorogov, Peter TV, Delovoye TV. So last time there was a conference in St. Petersburg, and Maria Chernobrovkina, the director of St. Petersburg Chamber of Commerce, speaking about the difference of lobbying between Western and Russian companies, said that Russian companies are targeted at receiving subsidies and state contracts, and foreign said, please don't interfere with us. And does this viewpoint exist? Do you have your own viewpoint on the difference? Natalia, will you try to answer? So, what do you think that foreign companies just say, don't interfere with us, and the Russian companies would say, give us subsidies, give us money? Actually, everything refers to the lack or the presence of lobbyism or civilized lobbyism traditions. If Western lobbyist companies perceive lobbyism as a professional activities in promoting someone's interests for certain money, unfortunately, some part of Russian representatives perceive lobbyism as not an activity, but an attempt just to earn money. I think that the question is there should be more foreign companies with foreign traditions of business conduct, and then there will be more competition. Is that the case? Yes. Another question.
Thank you very much. My name is Siddiq Sayed. I'm a professor in European law, Stockholm University. I wish to thank this excellent presentation by the panel members about the lobbying in different jurisdictions ranging from the EU, Russia, and the United States. I just want to make a few comments what Catherine has said. I'm not raising any issues. One thing is you said that unlike the United States, there is no payment for the political parties. I think I agree with you very much because at the EU level, you don't have really the American system of Democrats or something like that. But again, we have, like for example, the United Kingdom, you have the Conservatives and Labour. They are also represented in the European Parliament. So UK has almost the similar system in the United States. So that has to be qualified, I think, from my personal view. Then again, another thing is about lobbying on EU policy making. I think it's not just done in Brussels, it's done in all 27 capitals. So when it comes to decision making, this is what I learned from one of the former US ambassadors who was working in Brussels. So it's my personal experience. Then I think you also mentioned that there is no bribery corruption, but unfortunately, European Union is a huge bureaucracy with 7 very powerful institutions. So when there is power, of course, it's not immune from this kind of a problem. We had some very high sensational cases, I think, last year with the European Parliament, where some conservative MPs have to resigned, and I think there's some kind of a prosecution pending or some kind of misbehavior. And subsequently, European Parliament acknowledged this problem. They passed a resolution, and MEPs, whenever they are going to get given anything more than 150 euros, that should be disclosed to the European Parliament. So that's one problem. Again, also, the European Commission, they also have acknowledged this problem. There is a very powerful legal instrument on money laundering, which started in 1993. It didn't include the EU institutions, but subsequently, this problem became a big problem, bribery, corruption. Now, money laundering has included the institutions that you are not immune from this problem. And then, as you said about the joint register, I think this resolution came up after that, but we have to wait and see the European Parliament's resolution, because to my opinion, it's just merely a soft law, not a hard law. So it's going to be interesting to see how the European Parliament, because it didn't come from the Commission as a proposal, it was made internally, and we have to see to what extent they are going to respect. Thank you very much.
Спасибо за важное.
Thank you very much for this important comment. Then probably the last question that I will allow you to ask, and then we will finish. Just introduce yourself and your question.
Sergei Pepelev, partner in Pepelev Law Firm. We have discussed lobbying in legislative bodies and in the executive branch. Is there any lobbyism in the judicial system? Thomas, you said that you were also involved with the judiciary.
That I often use when I'm teaching a course in lobbying, and I ask students, can you lobby judges? Most of them say no, because after all, we're from a legal tradition that prohibits ex parte communication. Then I ask about what is an amicus brief? But a communication paid for to an agent to be able to provide a view to a decision maker by someone who's not a party to the transaction. Is that lobbying? Well, maybe. What about in the United States, we have a number of conferences that judges are invited to for education purposes, paid for by, for example, business interests and environmental interests. These are not overt lobbying, but they're education of a perspective intended to try to assist the judge's perspective. Having said that, I was actually hired by a client called Court TV that was a television network designed to cover gavel-to-gavel trials in the United States. And my job was to talk to judges and administrators across the country to try to open the doors of the courtrooms to television coverage and to Wi-Fi coverage. And that was pure lobbying. So the answer is, in administrative matters, certainly, that was lobbying. And when it comes to cases, it's obviously, there's no ex parte secret communications as there is in the rest of the lobbying world. But I think a lot of the efforts to persuade judges in cases, including going to the media, many lawyers in high visibility litigation now have public relations activities designed to try to set a stage. And these are all efforts to influence whether you call them lobbying or not lobbying.
Павел, совсем краткий комментарий, потому что мы...
Now a very brief comment. There is a book, a very interesting book, Lobbyism in the Judicial System of the USA. It was written by Professor Zebruk from the Institute of US and Canada. He was a major expert on the judiciary in the US. Thank you, dear colleagues. We have to wrap up. I would like to thank all the participants in our work today and the panelists. At least it was not a boring session.